SJC-13881, Daikin Applied Americas, Inc. versus Joseph Russo et al.
Okay, Attorney Melnick.
Good morning, Your Honor. Stephen Melnick, counsel for Daikin Applied Americas Incorporated, asking the court to reverse and remand the Superior Court decision below. Superior Court denied, in part, Daikin's motion for a preliminary injunction because it found that there was no irreparable harm. We disagree with that finding. The Superior Court should have applied a presumption of irreparable harm because this is a trade secret misappropriation case.
Can I just make sure I understand? So the part of the preliminary injunction that your client didn't get was the last part, right? The using the client lists.
Correct, Your Honor. It was a request for essentially for 1 year that they not solicit or do business with a limited list of customers.
And so if that, in that case, why isn't it that the loss of that opportunity for Daikin creates anything other than just monetary damages? You've got a discrete client list that they are able to use now, perhaps, but if you win, they won't be able to do it. So won't that just mean, you know, if you get damages from that, you get damages and you keep moving on?
Two reasons why there's irreparable harm, if I may, Your Honor. First, this isn't just a loss of contract or loss of business. This is dealing with loss of trade secrets. And the concept is that once a trade secret is lost, it is lost forever. And that's where we're getting to the presumption of irreparable harm, is that it necessarily flows one from the other, that if you lose a trade secret, inherent in a trade secret is that it be secret. If it's disclosed, then you lose the trade secret.
But there's not an allegation here, as there is in some cases, that the defendants are broadcasting this information. It's not like a loss of a trade secret in the sense of publishing this information so others will be able to have it. Then the judge, pursuant to the parties' agreements, ordered that the defendants had to cease using the information and in fact give it back, correct?
I believe so, Your Honor. It's not like they put it on the internet, that's true, but they did, what Mr. Porter did is he took hundreds of pages of Daikin's confidential information and he sent it to his own company. So it's somewhat of an internal disclosure, but there was still a disclosure from Daikin to another company, a directly competitive company that was formed while Mr. Porter and Mr. Russo were still.
But again, the only issue here with regard to the PI is the customer list.
Correct, Your Honor.
Okay.
Yes.
And when the defendants were at Daikin, they knew the customer list?
So, forgive me, Judge, it's
So
not
it's
just.
not secret as to them, right? It's just their use of it to solicit the customers.
So it's not just the list, it's not just the names. I mean, the names, yes, those are not secret. What Mr. Porter took was hundreds of pages of documents that go to how Daikin, which is an HVAC, they're both HVAC companies, so looking for.
Daikin.
How Daikin bids for a contract. So their prices that they bid to clients, the costs that they've negotiated with their suppliers, the profit margins between the two, historic customer preferences, things of that nature. So it's not just the list. I mean, we're not just discussing the list here. We're talking about essentially a roadmap. So RPAC had a roadmap of how can we go out and bid against Daikin to get customers to come to us rather than go to Daikin. We know that Daikin's margins are X%, their costs are Y, that their prices.
Is that the trade secret you're talking about?
Yes, Your Honor, among other things. I think that's the one that.
Those are the two, right? Margins and customer list, basically, right?
Prices, customer, I think we'd add customer preferences and things of that nature. So
that's the stuff. Okay, let's go back up one domino to the presumption.
Yes, Your Honor.
How do you get past eBay?
I'm sorry?
How do you get past eBay?
So a couple of reasons. One, that's federal standard, not state.
Well, we have never determined whether or not we should apply a presumption. And we look to help us when we have these circumstances to what they've done on the federal side. So not to say that it's conclusive, but to the extent it's persuasive. How do you get past, and in the eBay case was even further along than your case, because that was after a trial, right? And where the petitioner for the PI won. And even after that, the Supreme Court said that we're not going to do these presumptions, that you have to go and apply typical equitable principles. So why should we adopt a standard that says you have a presumption?
So eBay is dealing with patents, so patents are disclosed. By nature, a patent is published. Everyone can see your patent. It's just protected.
Yeah, but the bundle of rights that you get when you have a patent is the right to exclude. And the theory behind the presumption of irreparable harm or harm used to be, pre-eBay, that right to exclude was vitiated by the infringement of the patent. Trade secrets, all you have is the right to maintain your secret so long as it's secret, right? So there's not even the same bundle of rights that one would have in patent cases. So to the extent eBay vitiated that presumption, it actually is it's stronger for trade secrets, because that's an intellectual property right, but it doesn't give you the right to exclude.
I would come at it from a different angle, Your Honor. It's the very existence of a trade secret requires that it be secret. And unlike a patent, which is published for all the world to see, and you have to defend it, once a trade secret is disclosed or used or published to someone else, it loses its value. It's as if someone infringed on your patent and suddenly your patent goes away. That's the concept of a trade secret, is once it's disclosed, it's gone forever. That is where the presumption.
That's why I asked you the question initially. These individuals, the dependents, had access to that secret while they were employed by Daikin.
Correct.
Right. And so all they've done is taken that secret and started a new company. And if you prove a trade secret violation, then so long that, so much for their company. But in terms of the presumption of irreparable harm, there's not any indication, as far as I could tell, in the preliminary injunction record, that they're going to further disclose the secret, which they already knew.
I think once the cow's out of the barn, so to speak, Your Honor, then that trade secret's gone. So the next competitor could say, this isn't a trade secret because it's gone. You had somebody who took it from you.
Well, what's the evidence that any other third party is going to get this?
I'm sorry, Your Honor.
What's the evidence that any third party is going to get this in light of the agreed portions of the PI?
We don't have that evidence, but I'm talking about in the bigger picture of once the trade secret is gone, suddenly it's no longer a trade secret. So if it does get disclosed, the next person, let's say there is another employee who decides, okay, I just saw that this happened. I'm gonna post this on eBay, Facebook, whatever. Post it on wherever. Now, would we have no recourse because, well, it was already disclosed once. It's gone already.
Okay, but you sued under the Uniform Act.
Correct, Your Honor.
Right. So where in the Uniform Act, in the text of it, is there an embodied presumption?
It's not in the Act, Your Honor.
So again, just why do you get something that most folks looking for equitable protections, why do you get the presumption as opposed to just having to demonstrate it?
The presumption, Your Honor, if I may, is just a logical conclusion of the fact of the trade secret. Once a trade secret is used or disclosed, it's no longer a trade secret. You lose that value. So it's necessarily irreparable harm. You can never get it back. No matter what you do, no matter how many dollars you get, that trade secret is never going to be a trade secret anymore once it's been used or once it's been disclosed.
Doesn't the statute reference traditional equitable principles?
I do not know, Your Honor, but I would posit that this presumption has been applied before the Trade Secret Act went into effect and even after it.
What are the cases that have the presumption post-eBay?
We cite to a number in...
Just like the 10th Circuit case that you...
10th Circuit, there's a case, Inosis v. Mercer out of Utah, which analyzes this issue very well.
Why shouldn't we adopt the Second Circuit approach?
I'm sorry, Your Honor?
The Second Circuit approach.
Where they rejected the presumption?
Yes.
I mean, if I would step back...
In the absence of... They rejected the presumption, just to be more specific, in the absence of evidence of a further disclosure or threatened further disclosure of the trade secret?
I'd go first back to the argument, Your Honor, that the next person who comes along, the employees can say, okay, look, this trade secret's gone. It's gone forever. This isn't a secret anymore. This is no longer a trade secret because, hey,
I mean,
look.
that's almost inherent in the animal, right? I mean, the fact that you're suing the defendants for trade secret misappropriation means that it's gone, right? It's no longer secret. They now have it. I mean, so that's a different question from why we should continue or adopt a presumption that the federal courts seem to be moving away from.
I think it's it's gone point that you just made, Your Honor, is that is irreparable. There's no way we can ever repair that. There's no way that we can ever put that genie back in the bottle, put the cow back in the barn. Once trade secret's gone, it's gone forever, and it's lost forever. And once the special sauce, even if Burger King's using the special sauce recipe, and they don't tell anyone else.
Say that about the right to exclude. Once the right to exclude is gone, it's gone forever.
I would disagree, Your Honor. I think, again, because patent has a bundle of rights in itself. Trade secret, you have to defend yourself.
But you have here, right? The defendants, the plaintiffs sued and got the defendants to agree to multiple aspects of a preliminary injunction, right?
We did, Your Honor, but we still think we needed that extra step to protect our rights.
But can I ask you about that extra step?
Please.
Because you got an injunction against you. The defendants have been enjoined to return all the confidential information, and they were enjoined from using any confidential information. The only piece of the injunction you didn't get was a non-solicitation. Am I correct about that?
Yes, Your Honor.
I see that as a completely different beast. I see that as a substitute or for a non-compete, which you did not bargain for. Will you at least acknowledge that a non-solicitation injunction is broader than an injunction against not using confidential information? Right? I mean, okay, so how is it that any of what you've been arguing casts any doubt on the judge's denial of the request for the non-solicitation injunction?
So to deal with your direct question, Your Honor, and I'll broaden it if I may, our position is that they're already using the information. They'd had the information for months. They were already going out and making bids, and we know of at least one bid that they had gone out for.
Which they denied.
So if it's passed, that's usually not what an injunction's for. That's what damages are for.
At the time, Your Honor, they were actively bidding for other customers, and we were looking.
If they're not using a trade secret, see, this is the whole problem, I think, with this non-solicitation piece, is you're seeking to enjoin something that's broader than the misuse of an injunction, than the misuse of trade secret. And so if that's the case, how could you possibly be entitled to a reversal on the denial of that broader relief?
Our position would be that it's extremely difficult to police against someone misusing a trade secret once it's been disclosed, once it's been taken, once it's...
It doesn't mean, it might be difficult, but it doesn't mean you get to stop them from conducting all business.
We're not looking for them to stop all business. This is a subset, a narrow subset.
And it doesn't even, how is it that your trade secret entitles you to enjoin them from going out and soliciting some of your own customers? Your customers are not the trade secret.
Customers are not the trade secret, Your Honor, but we were just looking for assurances to make sure that they wouldn't take this information and go after this very narrow subset.
But why isn't that encompassed in the injunction number 2 part? Because you already got them to agree not to use the confidential information.
Okay, I think it goes down to the difficulty of proving that someone, once they had the information, once they saw the information, they had the information for months, being able to see that. But
it does go to, you just said that this goes to a subset of your client roster.
That's right.
So how do you square that with, I believe the quote in either your brief or your papers was that this was widely applicable to your business. if it's just a subset of that? And those are your words. So I would just, how do you square that? So again, how do you show irreparable harm in that context?
It was just a narrow subset that we were drawing, for the purpose of, asking the court for relief is what we were looking for.
But if you're doing that in the context of saying that you're going to suffer irreparable harm because it impacts, again, your phrase was, it was widely applicable to your business.
I believe, Your Honor, the distinction would be, these are the customers that we knew that the defendants had a relationship with and that were actually Daikin customers, as opposed to the thousands of other buildings and factories and office buildings and so forth outside throughout New England that they could go solicit. So when I said a subset, I meant a subset of the potential customers throughout the Massachusetts and New England.
Okay, thank you.
Thank you, Your Honors. We rest on our papers.
Dunbar.
Good morning. May it please the court. My name is Ronald Dunbar, and I represent the defendants. The Superior Court did not abuse his discretion when he denied Daikin's motion for a preliminary injunction seeking an order that the defendants not solicit any Daikin customers about which they learned confidential information or with which they had extensive contact for a year. As the justice pointed out, this is just an end around for a non-solicitation provision that they did not negotiate with these individuals. And the brief of the appellant ignores the fact they got an injunction. The confidential information was given back and they're prohibited from using any confidential information.
So how are they going to service any clients without the confidential information that they got and gave back?
Excuse me, Your Honor.
How are they going to do their business if they don't have the stuff, the information that they said they are not going to use?
They can conduct their business because they worked for years in that industry, and they can leave that industry and take whatever knowledge they've acquired. So they're able to run their business and not use any information that's considered to be confidential. And I think I want to make a little bit clear that before the injunction hearing, there was one customer, I believe it was the Lunenburg School, where there was arguably some information in there that could be considered confidential information or a trade secret, and that was agreed to be given back, which it was. And that was the reason why there was an agreement as to the two prongs of the injunction, to give back any confidential information if there was any, and not to use it.
There wasn't any in that in the Nokia case, the Nokia clients?
No, because the Nokia case, the testimony was that my clients didn't know about it until April, which was after they had left the employ. So they didn't take anything with them to actually bid that job, and they didn't get that job. With respect to Justice George's question about, how do you get around eBay? You really can't get around eBay. And the Massachusetts Uniform Trade Secret Act specifically does talk about injunctions, and it says, upon principles of equity, which is exactly what the eBay case says with respect to the trademark statute. And the court said, we're not going to displace years of equitable jurisprudence by writing something into a statute that's not there. It's exactly the same thing here. So if you wanted to have a presumption under the MUTSA, the legislature could put it in there. So I think it's impossible for them to get around the eBay decision.
I don't know that you're saying this, or the judge said this, but you're not suggesting that intentional misuse of trade secret, is always compensable, and therefore that you might never be entitled to an injunction.
Correct. I think that if, for instance, if the use of the trade secret was so pervasive that it put the company out of business where the trade secrets were taken from, you're certainly entitled to injunctive relief.
Anything less than that?
I think there's some case law that talks about loss of customers or goodwill, but in our particular case, the two prongs of the injunction that were agreed to protect them from that. Mm-hmm. So it's not like there's anything else they would get. And what they're looking for, this injunction to prevent solicitation, they don't even cite a case for it. I'm not aware of any case that would allow a court to write a non-solicitation provision in the form of an injunction for employees who didn't have a non-compete or non-solicit.
So in many ways, we don't even have to reach the presumption question. It's just, this is an end run around non-solicitation agreement.
I'm sorry, I missed that.
You wouldn't wanna.
We don't have to reach the issue of whether we should follow the eBay line of cases. As to trade secrets, we could simply say what the plaintiff here wants is an end run around a non-solicitation agreement, which it didn't bargain for when it first hired these employees.
Absolutely. And I think there's another reason you don't have to get to it, because the trial court found, and it was not an abuse of discretion, that they were unable to prove 2 out of the 3 prongs of a misappropriation of a trade secret case. He said there's disputes as to whether it was confidential or a trade secret, and whether they took steps to protect that information. So we really don't even have to get to irreparable harm or a presumption of irreparable harm.
And correct me if I'm wrong, factually, they couldn't have obtained a non-solicitation because they were members of a union, right? They had different rules.
Excuse me?
They couldn't have a non-solicitation with these union employees, correct?
That's the testimony, that because they're part of a collective bargaining agreement, that they could not be subject to any separate agreement with the employer, which I believe to be correct, but nonetheless, they didn't have one.
Could you just address the Eastern Marble case?
Eastern Marble?
Yeah. It's the case in which they're manufacturing the sinks, the marble sinks, and then they walk off and, they're doing the same thing for someone else. And they didn't have a non-compete, but we still sort of enforce that.
Yeah, so the cases that I found that were cited mostly in the brief, including that one, are cases where the employees actually did have non-competes or non-solicitation.
I thought this one didn't have, I thought they didn't have that one in that case.
Although in that case were the employees significantly senior, so that there was an implied duty of trust and loyalty to the underlying company, even without a solicitation agreement, right? It was like a 1970s case, right?
Well, I think with respect to the duty
Just to
of loyalty.
follow up on that point, just to follow up on the facts, don't we have a senior employee here who's similar in the sense that he's the chief supervisor who's involved in a lot of the bidding, creating the bids and the margins?
Yes, and I don't think we're arguing that there wouldn't be a duty of loyalty with respect to him. I think the biggest point to make is that he didn't violate, or the trial court found that there was no evidence that there was a violation of the duty of loyalty, and mostly because it was based on the same facts of the misappropriation of trade secrets, and there were those disputes of fact with respect to whether.
Did the judge, can you point to where in the judge's order you say that he found that? I read the judge's order as saying, even assuming that there was a showing of likelihood of success on the merits, although there are disputes of fact, even assuming there's no irreparable harm and that it rested squarely on the irreparable harm thing. What makes you read the order otherwise?
I believe with respect to whether it was a trade secret or confidential, or whether Daikin took steps to protect that information, the judge specifically said there are questions of fact as to whether that actually is the case.
He didn't resolve it one way or the other.
Well, he found that there wasn't a likelihood of success.
Where does he say that in his order? Where does he say that in his order?
Well, it doesn't. Those exact words are not in the order. But I think, and I read a case recently.
And isn't it just to tee it up a little more clearly? Doesn't he sort of apply a summary judgment standard on that, saying, okay, they're disputed facts, so I'm not going to do a reasonable likelihood of success analysis? And isn't that incorrect? I got confused by that.
It reads a little bit like that, Your Honor, but I think that, and I just read a recent decision by Judge Botsford when she was a Superior Court judge, and she essentially said, there's a dispute of fact here as to whether this information is true. There's competing stories, so I'm not going to issue an injunction because you can't show likelihood of success. And I think that's what.
That's different from what this judge said. He said even if Daikin could prevail on its misappropriation of trade secrets and duty of loyalty claims, i.e. they could show success on the merits, Daikin has failed to show that it will suffer irreparable harm without the PI.
Right, and I agree that that's separate. That's sort of the second part in my mind of the judge's decision, is he's saying assume for the fact that you could prove it, and that's where he says irreparable harm, its money damages will compensate you, so the harm is not irreparable. So those were the two parts of his decision, and the judge did not abuse his discretion with respect to that either, because the case law is pretty clear that money damages will suffice and it's not irreparable. And I think that's why the appellants want to reach for a presumption that they're not entitled to and is unsupported by the case law.
Good.
If you don't have any further questions, I'll rest on the brief.
Thank you.
Thank you.